Great. On behalf of the Duke Law chapter of the American Constitution Society, I want to welcome everyone tonight to our North Carolina Supreme Court Candidates Forum. I am Paul Finkelstein, president of Duke Law's ACS chapter. I want to start by thanking the Bolch Judicial Institute for co-presenting tonight's event, as well as our student organization co-sponsors, the Government and Public Service Society and the North Carolina Club. Also, thank you to the Duke Law staff, including those in facilities, events, and instructional technologies who have been instrumental in preparing for tonight's event. For those who don't know, ACS is the nation's foremost progressive legal organization with over 250 student and lawyer chapters across the country. Like Duke University, however, we are a 501c3 nonprofit, nonpartisan educational organization. Neither ACS nor Duke endorse any candidate or party tonight. ACS National's theme this year is Democracy's Moment of Truth. For democracy to persevere, we need folks in elected office representing all parties who are committed to the rule of law, to the Constitution, and to election integrity. Elected officials, including justices of the North Carolina Supreme Court, are critical to the running of our elections and to protecting the guardrails of our democracy. Our goal tonight is to shine a spotlight on this important race and critical office. We sincerely appreciate the participation of all the candidates with us here today and look forward to learning more about them. Our moderator tonight is Professor Marin K. Levy, who has been a member of the Duke Law School faculty since 2009. She writes and teaches in the area of judicial administration and appellate courts. She currently serves as the director of Duke's program in public law and is the faculty director of the Bolch Judicial Institute. Prior to coming to Duke, Professor Levy served as a law clerk to Judge Jose A. Cabranes of the U.S. Court of Appeals for the Second Circuit. A huge thank you to Professor Levy for moderating our forum tonight, and with that, I'll turn things over to her. Thank you.
Wonderful. Well, thank you so much, Paul, and to the American Constitution Society and to the Bolch Judicial Institute for organizing this wonderful event tonight, and of course to the candidates for being here and being so generous with their time. So I'm briefly going to set out the ground rules for the format tonight, and then we will get into questions for the candidates. So we have a number of questions for the folks up here tonight, ranging on topics such as their own past experiences in life and their judicial philosophy. And the same question will be posed to each of them. And they will be responding to the questions in an order determined by a random draw that took place earlier today, and you can see it reflected in the seating. So for the first question, we will be hearing from Judge Dietz, and then Justice Ervin, and then Mr. Allen, and then Judge Inman. For the second question, we will move down, and so on and so forth. Each candidate will have up to 2 minutes to offer a response with no follow-ups. And we have some wonderful timekeepers right here in the front row who will be reminding us as we are getting closer to the end of that time. And if need be, then at the 2 minutes, it won't be needed, but then I will step in to do a little bit of wrangling. As a reminder, this event is being recorded and also live streamed. And we would just ask our wonderful audience here to hold out on applause or otherwise making noise. Right? We don't want any of that tonight. All right, with that, we will get into our questions for tonight. So Judge Dietz, I hope you will start us off. To open, we would love for our candidates to give us just a bit about their background and really just to introduce themselves to our audience.
Sure. So thank you, Professor Levy. Thank you, ACS and the Bolch Institute for organizing this. Thank you all, the students I see here in the room, and thank you to everyone watching at home. So this is great for us to be able to educate the public, so I'm excited to be here. My name is Richard Dietz. I'm a judge on the Court of Appeals. I've served on the Court of Appeals for the last 8 years and have decided to run for an open seat on the Supreme Court of a retiring justice. And so my journey to the Court of Appeals began because I was an appellate lawyer for my entire career. I'm from a small-town family and was the first in my family even to go to college, but I always had a passion for the law. I did well in law school. I was first in my class at Wake Forest Law School. I have a master's degree from here at Duke. And I went on to build a practice that I called Issues and Appeals. So I've handled appeals all over the country in state and federal courts, including I've stood and personally argued in the U.S. Supreme Court. And I brought that experience to the Court of Appeals, but I think we now need it at our state's highest court. And I made the theme of my campaign leadership for our courts, because I believe that what our court needs right now more than anything is to have folks that can come and bring the court together. I think there's a lot of politics that are at the court. There's also a lot that the public sees and believes that the court is being political, and we need to fix that. And so I'm going to bring that leadership. I have the skills and the experience that we need, but I also have the character and the temperament to work with the justices that are on the court now. I've served with Justice Ervin. I've served with almost half of the justices that are currently there, and I work with all of them on various committees and commissions. And I think most importantly, I also have ideas for leadership that go beyond the courtroom. And I think we need that as well in justices in our state's highest court. I've always been a leader in finding ways to help improve the court system, and I'm going to bring that leadership, lowering the cost of legal help, finding ways for people to access the courts in better ways, and helping students like you. So the appellate seminar, a constitutional academy for kids that were stuck at home during the pandemic. I have lots of ideas, and I'm going to bring that all to our state's highest court. Thank you.
Wonderful, thank you. Justice.
All right, good evening, everybody. I want to join Judge Dietz in thanking all of you for being here and for giving us an opportunity to have this discussion in front of you, those of you who are here in person and virtually in front of you to the extent that you're watching on the live stream. My name is Sam Ervin IV. I'm currently an Associate Justice of the North Carolina Supreme Court, and I'm running for re-election. I'm a native of a little place in western North Carolina called Morganton. It's right at the foot of the mountains. I've lived there all my life except when I was off in college and law school. It's a small town community of lots of different kinds of people, and that background is shaped, I'm sure, the type of person I've become. I'm a product of the public schools in Burke County. My mother was a high school history teacher. I went to Davidson College undergrad, graduated magna cum laude, went to Harvard Law School and graduated cum laude, and then did something that not many Harvard Law graduates do, which I went back to my hometown of Morganton to practice. Had a very varied practice that included lots of jury trials, lots of appeals, some office work. About anything you want to do, anything that walks into a small town law office, I did. In 1999, I was appointed to the State Utilities Commission, served on that body for 9 years, was elected to the Court of Appeals in 2008, served on that body for 6 years, and then was elected to the Supreme Court in 2014 and has served on that body since January the 1st of 2015. I'm running because I believe my record shows that I can fairly and impartially decide the cases that come before the court. I've got a record of deciding cases because of what I think the law is, not because of any kind of political consideration. I've voted against the position that one would assume I might take given my political affiliation. I think that's the kind of justice that we need on the court. And so I'm seeking re-election and hope that I have the public support.
Thank you. Mr. Allen.
Good evening, everyone. I want to echo the thanks that have already been issued. I am Trey Allen, candidate for the North Carolina Supreme Court. I currently serve as the general counsel for our state's court system. So our judicial branch has over 6,000 personnel, judges, clerks of court, magistrates, and support staff. I run the office of 11 lawyers in Raleigh who give legal guidance to court officials in criminal matters and civil law matters. We do that regardless of party. We do it in a non-partisan and an unbiased way. I'm also the Coates Distinguished Term Associate Professor of Public Law and Government at the UNC Chapel Hill School of Government. So no booze, please. I grew up outside of Lumberton, North Carolina. I'm the first person in my immediate family to obtain a college degree. I'm the first lawyer in my family. I served 4.5 years in the United States Marine Corps out of law school. Most of that was overseas. I did do a tour in Iraq. I clerked for a justice on the North Carolina Supreme Court when I came back. I practiced law and became a partner at a law firm in Raleigh. I represented school systems around the state, so I handled constitutional law claims and other civil law claims made against school systems and school system personnel in state court and federal court at the trial level and the appellate level. And then in 2013, I went to the UNC School of Government, and the School of Government is a unique organization. Government officials, including judges around the state, rely on School of Government faculty members to provide unbiased and thorough legal analysis on a wide range of issues. I'm running for the North Carolina Supreme Court because I'm concerned that a growing number of people in our state perceive our state's highest court as a body that makes decisions in politically charged cases based on politics instead of on the law. I think that's detrimental to our system of justice, and that it's important that we do what we can to restore the public's confidence in our court, and I want to do what one person can to do that.
Thank you. Judge Inman.
Well, thank you again, everybody. Thank you, Professor Levy, and to the Constitution Society and the Bolch Institute. My name is Lucy Inman, and I am in my 8th year serving on the North Carolina Court of Appeals. I am running for the open seat on the Supreme Court that Judge Dietz is running for. And, you know, I don't have a one-word theme. I'm running for reasons which you may be reflected in some things you've already heard tonight, to preserve the integrity of our Supreme Court at a time when state Supreme Courts are being asked to make some of the most difficult decisions they've been asked to make in my lifetime. I'm also running to protect the independence of the judiciary and the rule of law from partisan political influence and personal and political agendas. And finally, I'm running to make sure that our Supreme Court continues to protect every person's state constitutional rights as well as their federal constitutional rights. I grew up in Raleigh, no lawyers in my family. My first experience in a courtroom was after college. I graduated with an English degree from NC State, and I worked as a newspaper reporter. And what I saw happening in the county courthouse persuaded me that I wanted to be involved in the justice system. I then went to UNC School of Law and graduated with honors there and served for 2 years as a clerk for then Chief Justice Jim Exum on the North Carolina Supreme Court. I then practiced law for 18 years, representing people from all walks of life. And in 2010, I was appointed to become a Superior Court judge. I used to say, have gavel, will travel. I served in courtrooms all across the state, and I know from my experience in those courtrooms that every case involves real people, and I bring that perspective and look forward to answering your questions. Thank you.
Wonderful. Well, thank you all. So to get into the questions a little bit further, so there's a great story about two figures in law, Justice Oliver Wendell Holmes and Judge Learned Hand having lunch together. And as they were parting, Judge Learned Hand said to the justice, "Well, goodbye, sir. Do justice." And Justice Holmes responded, "That is not my job. My job is to play the game according to the rules." So the question is, how do you all see the role of a justice on the Supreme Court of North Carolina? Justice Ervin, we're going to start with you and go down the line.
Right. It seems to me that the principal job of an associate justice of the North Carolina Supreme Court is pretty simple. We are not responsible primarily for administering the court system. Our job instead is to decide each of the cases that come before the court in an appropriate way. And what that means to me is pretty simple. We're supposed to look at two things and two things only in the course of making our decisions. First, what are the facts of that particular case? The luxury that we have as appellate judges is, for the most part, the factual determinations are made in the trial courts, and we have rules that we have to follow in order to decide what the facts that we use are, but those are pretty well established below. Then we try to figure out what is the law that applies to this set of facts and what result does it call for. My dad was a Superior Court judge and a Fourth Circuit judge for many, many years, and he used to say that members of the judiciary did not have what he described as a roving commission to do justice. And what he meant by that was, we're not there to decide what we think is subjectively fair. If we all did that, then nobody would know what the rules were, and so we can't operate on that basis. Our job is to figure out specifically what is the law that applies to the set of circumstances that we've got before us, construe it as best we can, and make sure that we apply that law to the facts, giving everybody a fair opportunity to be heard, treating everybody equally under the law, and making an appropriate decision based on those criteria.
Thank you. Mr. Allen.
Well, I agree with all of that. I would just add that, you know, one of the primary purposes of the North Carolina Supreme Court is to make sure that the lower courts, the Court of Appeals, our trial courts, have gotten the law right, that they understand the law. And so it's vital that justices understand that when they write an opinion on a matter, that may be the only appellate law in that area for decades. And I encountered numerous situations like that as a faculty member at the School of Government, you know, writing pieces on various subjects you know, for example, the North Carolina Supreme Court wrote an opinion within the last few years on the police power of local governments. Well, there's not a lot of case law on that. It was the first decision by the court on that subject, I think, in several decades. So, and there may not be another one from the North Carolina Supreme Court for several more decades. So, because the lower courts are bound by decisions of the state Supreme Court, it's vitally important that the court understand that its decisions might stand for decades, and they need to be right because they're going to constrain the lower courts until the state Supreme Court says otherwise.
Great, thank you. Judge Inman.
Thank you. Well, you know, I think that Learned Hand and Oliver Wendell Holmes were both right in a sense, really. I totally agree with Justice Ervin that no judge has a roving commission to do justice. And the rule of law is what keeps our court system stable, what lets people know what are our rights, what are our responsibilities, and the way that we ensure that we're treating every person before the court consistently and equally with others like them in their situations is that we follow rules and we say what the rules are so that people know what rules we're following. Sometimes, of course, in cases of first impression, there are no clear rules, and that's when it becomes challenging. But usually there are rules of analysis that have been set out in earlier cases. I really believe precedent is very important. I believe that any judge or justice who believes that he or she is so smart and so enlightened that they know better than precedent is a very dangerous thing on the North Carolina Supreme Court because indeed its decisions are the last word on many issues of law. It is not an academic exercise. It is not, I don't agree that it's a game of following the rules, if that's what was said. It is so much more important than a game. We must follow rules, and we do justice when we follow the rules consistently and transparently. And if there's not a set rule, we do what our middle school math teachers told us: show your work and explain how you got there. Thank you.
Thank you. Judge Dietz.
So I've heard that story about Holmes and Hand several times, and I assumed it was apocryphal, but Professor Levy, if you say it happened, then it happened.
It did happen. Judge Learned Hand said it happened.
All right, so it reminds me of a story about investing financial planners. So there's someone once said, you know, your options are when you're investing your money, you can either eat well or you can sleep well, but you can't do both. And I've always thought, I don't agree with that. I think if you're good, you can do both. And I think that's the message, the takeaway I have from that story also is that we need to follow the law as judges. And so, you know, in the sense that we are playing the game in that way, I think that is what we do. And sometimes we may feel like I don't like this result, but we're still doing justice if we can reassure the people that come before us and reassure the public that we are following the law. And I have a story about that, a quick story I can tell you, because when I had two clerkships, one in the federal district court in Virginia and one on the Fourth Circuit. And the district court judge I clerked for, I watched him do that one time with a pro se litigant who came in with a meritless argument, but she wouldn't stand up. She had crossed her arms, and when the judge came in, "I'll rise," she said, "I'm not gonna rise." And the marshals were gonna make her stand up, and the judge waved them away. And instead what he did is he explained to her that you don't rise for the judge, you rise for the system, and he talked for a long time about how he would listen to her argument and consider it and be fair. And I'll always remember at the end of her argument, he dismissed her case. But then when they said, "All rise," she stood up and nodded. And I think that's what we can do, is bring justice in that way, reassure people that the courts are following the law, but in a way that the public says, even if I don't like the result, I too, just like the judges, can feel comfortable about the system. And so I think that's the kind of message, the kind of leadership that I'll bring to the Supreme Court.
Thank you. So despite how important it is, the work of the judiciary can seem confusing and even inaccessible to many voters. So given the significant role that the Supreme Court of North Carolina plays in the lives of North Carolina citizens, how would you seek to enhance the knowledge about the court's work and broaden the understanding of the functioning of our judicial system? Mr. Allen, we'll start with you.
Yeah, I think that's a great question. I'm the only candidate up here who was in a primary. So I've been campaigning a long time, since the beginning of last year, going around the state. And there is a real dearth of knowledge about our courts and how they function and about the Supreme Court. I can't tell you how many times I've been asked, even at events with people who are politically active, am I in your district? And people don't realize that these are statewide elections. So it is an important topic. I think there are a couple things. One is, I think Supreme Court justices need to avoid simply hiding in chambers all the time. I think they need to be out there. I think they need to be engaging the public. They need to be looking for opportunities to talk to civic groups and other organizations to educate them about our courts. And then in the way we write, that justices write opinions, I think that's vital too. To write them in ways that are in such a manner that they're accessible, that people that a reasonably intelligent person can look at them and understand how the court got to the conclusion that it did. If it takes you 100 pages to explain a relatively simple ruling, you're probably not doing a great job as a legal writer. And you may already know that lawyers aren't necessarily great writers. So we need justices on the court who are going to engage the public and who are going to write opinions in ways that will allow people to understand how the court got to the result it did.
Thank you. Judge Inman.
I agree that no judge should hide in their chambers, and it is incumbent upon us to get out there in the communities to hear people's concerns and to answer people's basic questions about how the judiciary works. When I was a newspaper reporter wandering around the Wake County Courthouse without a clue of how things work, many kind lawyers and judges would say, you know, if you'd like to know on background what just happened, I'll be happy to explain that to you. What justices on the North Carolina Supreme Court can do to improve the public's understanding of what's happening is, number one, speaking to groups and letting people know all the ways in which the courts affect their lives. And number two, as I said a few minutes ago, in every single opinion, do what your middle school math teacher told you, and I was bad at math, and that is show your work. When I write each opinion, I think of the first couple of paragraphs of that opinion like the lead in a newspaper article. I want an 8th grader to be able to read the first few paragraphs and understand what the issue is, what the court has decided, and at least a forecast of why the court reached that conclusion. Also, for me, this careful approach to writing in plain language is a test for thinking and analysis. And I don't know if any of you have experienced this when you're working on a paper that you're writing or something else. You think you've got the analysis down. You think you know how it's going to follow, and then it just won't write. It's not, you can't say it in plain language. And that's a clue that maybe you need to go back and reconsider your reasoning. And Supreme Court justices, above all, must be open to the idea that they may not have the right answer and they need to think about it and listen to others. Thank you.
Thank you. Judge Dietz.
Yeah, I've had this experience because this has happened several times during this campaign. I've been places like the county fair, and I've just been talking to people, you know, are you a Panthers fan and that sort of thing, and then get to know them, and then I tell them I'm running for Supreme Court, and I explain a little bit about me and that sort of thing. And if I say, you know, you've got me convinced, I believe in you, I'm definitely going to vote for you, and, you know, I'll be rooting for you when you get up there to Washington. And I'll just say, whoa, let me back up and tell you a little bit more about the court system and what I'm running for. And but I think that's because, you know, the public, they have busy lives, and the court system can be complex. I do think that it's a responsibility of judges, lawyers, everyone in the profession, but I think especially judges, to help inform the public about what it is that we do. So I've worked on that for a long time, and I can give you some concrete examples. So if you go to my YouTube channel, it's YouTube/Judge Richard Dietz, you'll see a cartoon version of me. So instead of sending out sort of spammy political emails during the campaign, I said, how can I tell people a little bit more about who I am and about the court system, but in a way that's, you know, interesting and isn't political? So I created cartoons. I mean, these aren't Pixar quality things. I've got a freelance animator that does them, but they're a way for lawyers and the public to get a little bit of insight about what we do as appellate judges. And I found that the public really enjoys them. So I thought it would be mostly lawyers kind of commenting on them. Instead, it's the public, asking questions and talking about what they learned. And I think that's what we can do more as judges. And we've learned a lot about technology through the pandemic. So we're a lot better at making videos and that sort of thing now. And I think we can use that to help spread this awareness and educate the public about what we do.
Thank you. Justice Ervin.
And I want to echo the theme that you should have heard from all of us, that this is an important problem that needs to be addressed. When I got to the Supreme Court in 2015, we had a meeting of the members of the court, and one of the things we decided to do was to make civics education a priority for the members of the court. And so, along with another member of the court, I was put in charge of our civics education effort. Now, it's probably not I can guarantee you it was not as technologically sophisticated as what Judge Dietz described, because no one would accuse me of being technologically sophisticated. I would have to plead, could not be convicted of being technologically sophisticated. But what we did was we set up a speakers bureau, and we all committed to go out and make talks with school groups, civic groups, religious groups, and we spent, up until the pandemic, all of us did that. There was some reluctance, I think, on the part of the public to ask us to come do that, because they thought, oh, nobody will do that. But we all did. We had a period of time where we were celebrating the 200th anniversary of the creation of the court. It again was cut short by the pandemic, but we used those court. We were allowed to hold court outside of Raleigh. Normally, we can't hold court anywhere but Morganton, Raleigh, and Edenton. But we were allowed to go all over the state for a period of 3 years, and one of the things that we did during that process was put a real emphasis upon going into schools and to talking with school groups about the importance of the courts. And so this is something that I've worked on very hard throughout my entire period on the court. I think it's really important. I don't know why the level of public understanding of the courts is not any better than it is. We can't fix it from within the judicial system, but we have an obligation, each of us, to try to do what we can to make sure that the public understands what we do.
Thank you. So there's a concern today that members of the public think that the judiciary has become too political or even partisan. So what would you say to North Carolinians who have these concerns about our own judiciary? And Judge Inman, we'll start with you.
I would say you're right to be concerned. I've certainly been concerned for years. The landscape has changed in North Carolina dramatically in the last several years. In 2014, when I was elected in a nonpartisan election to the North Carolina Court of Appeals, candidates didn't have a partisan label by their names. This created an extra burden for candidates to try to talk to people about why they should be elected that had nothing to do with a partisan label, that had nothing to do with partisan politics. And I was very gratified to be endorsed by retired judges and lawyers who were not of the political party that I had been affiliated with. Our legislature, sadly, in my view, in 2015 made the Court of Appeals races partisan. They then made the Supreme Court races partisan and all the trial court races partisan. When you put a partisan label on a judicial candidate, it creates a hope, perhaps, of people who share that judge's party, or a fear from people who aren't in that judge's party, that the judge is going to be towing a partisan line. The North Carolina Bar Association this summer had a symposium on threats to the independence of the judiciary, and one of those threats was identified as partisan judicial elections. A poll of non-lawyers, 71% said they would prefer nonpartisan judicial elections, and a poll of lawyers, 75%. I am a person, not a partisan. We've seen partisan activities in the campaigns and the primaries this year, and we've seen partisan activities by judges who are not even on the ballot. Thank you.
Thank you. Judge Dietz.
So we've done a lot of these candidate forums, and there's sort of a joke that we all end up saying a lot of the same things. And so here, I'll break the trend a little bit, because I'll disagree with one thing that Judge Inman said, and that is, I think when I heard her explanation, I heard something of a causal link between the party labels and how politicized the courts have become. So I'll give you a counterfactual on that. So I was last on the ballot in 2016, 2 years after Judge Inman. That's when the races were partisan. So it had the party labels on there. And I received the same long list of bipartisan endorsements from former chief justices of our court, Democrats and Republicans, and all sorts of other judges and folks in a bipartisan way. I received all the newspaper endorsements, all of the legal groups. And so I'm not sure that I agree that something's changed, that things feel political right now, but I'm not ready to just say, I know what the answer is. I want to study the question. I want to find a way to fix it by doing what we should be doing as lawyers and judges, which is looking at the facts, gathering that evidence, and looking at data, and then applying reason and saying, what is going on here? Because I completely agree with Judge Inman that the courts have become too political. The public perception of the courts has become very political, and we need to fix it. One thing that I think we need to do as judges is commit ourselves not to run political campaigns. So as I mentioned earlier, I've made the theme of my campaign one that doesn't have anything to do with politics, and I've used my communication with voters to stick to that message. So like I said, the animated treatise that I'd used and other things like that don't talk at all about politics. And if you look at my public presence, my social media, all those sorts of things, you won't see me hanging out at political events. And I think that's what we can do as judges to reassure the public that there is no politics in what we do.
Thank you. Justice Ervin.
And I'm trying to figure out how to answer this question without repeating everything that's already been said, but let me take a stab at it this way. I think to the extent that the public believes that courts have become more politicized, that's very harmful to the courts. And I think a system that encourages voters to look at courts as if they were partisan institutions does a disservice to the public, and it does a disservice to the court. When we went back to partisan elections, and we became the first state to move back to partisan elections in nearly a century, I think that was a misstep, because when you have a partisan election and you make people run on a partisan ticket, the signal that you send to the average voter is, this person is a partisan candidate, evaluate this person on the basis of political considerations. As I said in my opening statement, we should not do that. Another thing that concerns me greatly is the amount of money that's being spent in these races. It's gone up exponentially since I started running the first time. And I think that also harms public perceptions of confidence in the judiciary. How do we do something about it? We don't make the rules. The General Assembly gets to make those rules. I don't know very many judges that wanted to make the changes that were made, but they were made anyway. What we can do is do the best that we can to, first of all, communicate to the members of the public that these are not partisan institutions, and secondly, act in our judicial capacity in such a way that we demonstrate that we are not making political decisions. I said in my opening statement that I can point you to a number of decisions that I've made at the Supreme Court that one would not have predicted based upon knowledge of my partisan affiliation. I did it not because of any political consideration. I did it in spite of the fact that I suspected that some people that I'm affiliated with the same party wouldn't like it. But I did it because that's what the law requires. We do more of that, I think that'll help the public perception.
Thank you. Mr. Allen.
I've been a fairly close watcher of the North Carolina Supreme Court since I clerked there about 18 years ago. And I think one reason that people see the court now as more political than they have in the past is because over the last few years, there have been an increasing number of cases that have broken down on party lines, especially the high-profile cases. That's different than it was years ago. So when you have a court where every time there's a big political case that comes up in front of it, or most of the time when there's a big political case that comes up in front of it, splits, 4-3, or where even on decisions about whether to bypass the Court of Appeals in cases where those decisions, those procedural decisions break down 4-3, the inevitable result is people are going to look at the court and say, well, they're making decisions based on, their political background. I don't see any way around that. I don't have data to back up this next assertion, but surmise. My guess is that those kinds of decisions, that increasing track record of 4-3 decisions, contributes more to people seeing the court as political than the mere fact that there are partisan labels on the ballot. And I think that one way to deal with that is to be sure, and I tell people this, when I'm campaigning, you need to look at the judicial philosophy of candidates. Do they have a set of principles that will allow them to make decisions based on principle and not politics?
Thank you. So the North Carolina Constitution has been rewritten twice, most recently, I believe, in 1971. So can you describe what your approach would be or has been in interpreting the text of that document? So for example, some jurists, of course, favor originalism, others favor what we might call living constitutionalism. So how would you describe your particular methodology? Judge Dietz, we'll start with you.
So as you might imagine, we get asked this question at every forum also, and I think one of the problems is for the public, they understand what those words mean, at least the way they're often used in places like the press or the media. So you hear originalism and living constitutionalism, and what typically it means when you're talking about that is the absolute most extreme versions of those two competing constitutional theories, both of which I think if you go to either extreme lead to the kinds of judicial activism that everybody that's sitting up here in this forum today is going to say we don't want to see in the courts. And I think it's hard because in that spectrum, when you start saying where do you fall, it's very hard to describe, especially when you only have 2 minutes. So I'll give you a couple examples of how I approach constitutional theory. One is I care very much for the idea that we, the people, matters. And I worry that if courts are too aggressive trying to interpret the Constitution, it can harm not only sort of the core concept of popular sovereignty that we have, but also the notion of self-governance. So a big part of my approach is what I just think you describe as judicial restraint, but the understanding that before the court acts, we should think carefully about what we're doing, because the public, if they lose confidence in the courts, then we no longer have our power because we depend entirely on the public trusting that we're independent and that we're not acting as a political body. So that's always in my mind when I'm interpreting the Constitution. And then I also apply to some extent the notion that, especially with the North Carolina Constitution, it's a very special document. So one thing that I have advocated for is not to lockstep the important rights that we have in our Constitution with federal doctrine when there is no federal counterpart. We have so much wonderful language in our state constitution that's idiosyncratic. You won't find it not just in the federal Constitution, you won't find it in any other state. And that's a very important part of our Constitution, and it's one that I think judges and lawyers need to spend more time studying, understanding, and advocating for in the courts.
Thank you. Justice Ervin.
Professor, I'm going to start off by saying that actually we've had 3 constitutions and 2 major sets of amendments. So this is, we had the first one in 1776, the next one in 1868, and the last one in 1971, plus major amendments in the 1830s and the 1870s. The North Carolina Constitution is to be interpreted in accordance with the rules that the North Carolina Supreme Court has already laid down for how to do that. I've always felt like this originalism, living constitution discussion involves a false dichotomy. Those are 2 academic theories. We have laws in this state that say how the Constitution is supposed to be interpreted, and those are the rules that I follow, and they're pretty simple. First of all, what does the thing say? We've got a provision, it's written in language. If it's clear and unambiguous, you're supposed to follow the clear and unambiguous language and not worry about anything else. If you have ambiguous language, it can mean more than one thing. There are a series of things you're supposed to look at. You're supposed to look at what is the context in which the provision appears? What do other relevant provisions say? What was the purpose for which the provision was adopted? The cases use the word, what is the evil that was intended to be addressed? What is the historical background against which it was adopted, and what is the precedent of the court interpreting that provision? Those are the things that you're supposed to look at. You're not supposed to follow any type of academic theory. You're supposed to do what the law requires, and part of what the law is the set of rules that we use to interpret the Constitution. And so I don't buy either of those 2 theories. The theory I buy is the more practical analysis that our case law calls for, and that's what I've tried to do when I've interpreted the Constitution.
Thank you. Mr. Allen?
So one interesting thing about our state constitution, when you talk about originalism, so the idea being that courts should look at the way a provision was understood at the time it was ratified, is that we have had 3 constitutions. And so you have provisions, there are several provisions in our current state constitution that go all the way back to the 1776 Constitution. So the historical analysis can become a little complicated because you're not just looking at how was it understood in 1776 or 1868, but also how was it understood in 1971. So there's that practical side of it. But, you know, the idea of originalism is that the whole purpose of it is to ensure that judges act like judges and not like legislators, that judges recognize that there are constraints on them. It's like when I take my 6-year-old bowling. They put up the bumpers so he can't roll a gutter ball. You know, those bumpers keep him in his lane. Well, that's the idea behind originalism. Judges acting like judges, recognizing that they are bound by the Constitution just like everybody else. So I do think you start with the history and the text. I think that where there's precedent, you follow that precedent, except where there's good reason not to. And you may follow that precedent even if you disagree with it, or that is, even if you would have decided the case differently if it were a case of first impression. So I'd say look at the text, the history, follow precedent, except when there's a compelling reason not to do that.
Thank you. Judge Inman?
Thank you. Well, yes, as the last person to answer this question, I can hear echoes of different things I might agree with what we've already heard. But I will start out by saying, like Justice Ervin, my judicial philosophy and how I interpret the North Carolina State Constitution is derived from precedent, decisions written by the North Carolina Supreme Court about how to interpret the North Carolina Constitution. And while I do agree that we, the people, are important for representative government, the very reason that we have in Article 1 of the North Carolina Constitution, the Declaration of Rights, is that some rights are so fundamental, they are to be protected even when the vast majority of we, the people, might like to take them away. Even when the vast majority of we, the people, might like the court to just exercise some restraint and not meddle. One decision from the North Carolina Supreme Court that is still precedent today, and I hope it remains precedent after November, is a decision from 1992 written by Justice Harry Martin, noting that the North Carolina Supreme Court, the courts have the sole duty to interpret the Constitution and the law. That's a duty that the courts have that the other branches don't have. And because the court has that duty, the North Carolina Supreme Court has a duty to look at our state constitution, every provision, and liberally construe any individual rights that are in that document to protect our citizens. That is the precedent about how we should look at the North Carolina Constitution, and I will follow it as long as it is precedent. Thank you.
Thank you. So we've just touched on the topic of precedent, which is perfect because it sets up our next question. So what is your view of the role of stare decisis, and how do you know when it's appropriate to overrule past precedent? And Justice Ervin, we'll start with you.
Well, I hate to sound like a broken record, but I guess I'm going to. Not only does the court have an extensive jurisprudence on how constitutions and constitutional provisions should be construed, we also have decisions that indicate when it is and is not appropriate to overrule precedent. I think the leading case on that one is a case from the late 1940s or early 1950s that my grandfather wrote when he was on the Supreme Court called State versus Balance. And State versus Balance involved a situation in which the state had enacted a statute regulating the business of photography, and there was an economic due process claim brought against the state in that case. A similar statute had been upheld, but the court in this case overruled its prior precedent and talked about when it was appropriate to overrule cases and when it was not appropriate to do so. And they started out by saying, first of all, that no court, I think the language was that no court had been more faithful to precedent than the North Carolina Supreme Court. That, whether you want to buy that as accurate or not, I'll let somebody else make that decision. But it says, first of all, that adherence to precedent is a bedrock principle and that you should not depart from precedent except in very unusual circumstances. And the two things that were set out in that opinion as the circumstances that justified overruling precedent were, one, that the initial decision was plainly wrong, and secondly, that that decision worked a grievous wrong when it was applied. So the rule in North Carolina is that we follow precedent except in extraordinary circumstances, and you don't follow it only when you are completely and fully satisfied that the earlier decision was incorrect and that continued adherence to it works a grievous wrong. And that's the approach I would follow in determining whether to depart from precedent or not.
Thank you. Mr. Allen.
Stare decisis is indeed a bedrock principle because without stability in the law, you can't have the rule of law. The basic, concept of the rule of law is that you get the same rules applied to people in similar circumstances. So, stare decisis is key. And certainly, if I'm elected to the North Carolina Supreme Court, that's the approach that I would take. And I'd like to sort of just amplify something I said a little earlier. I mentioned that, stare decisis sometimes means that you stand by the thing decided, and literally the Latin is to stand by the things decided. Even if you might have decided the cases differently or the case differently had you been on the court when the decision in question was made. So I remember hearing an interview with Justice Ruth Bader Ginsburg one time. She was talking about Chief Justice William Rehnquist and how he had been a real critic of the Miranda decision. But when the opportunity to overturn Miranda came up, he voted to support its continued validity because he recognized that so much of our criminal justice system had become ordered around the Miranda decision. So, and for me also, I think that something that perhaps, and I don't mean to criticize anyone on this panel, but sometimes people put on the black robe and humility goes out the door. To me, an important component of stare decisis or a reason for stare decisis is humility. The recognition by judges that they don't know everything, that their predecessors may have decided things the way they did for reasons that made sense, that the current judge doesn't necessarily see. So I see a lot of validity in stare decisis, and I would follow that rule and not overturn precedent except when a compelling reason existed for doing so.
Thank you. Judge Inman.
So now I'll sound like the broken record because indeed, I think stare decisis is one of the most fundamental principles in our rule of law. In 2016, it was a Thursday. It was a Thursday after Election Day, and I was at a conference in Washington, D.C., a national judicial conference. There were federal and state appellate judges there from all across the country, and this group usually has a Supreme Court justice as the guest speaker, and that year the speaker was Justice Elena Kagan. And she gave some remarks, and then it opened up for questions. Well, many, many hands went up. And the first person asked a question, and then hands went down, which suggested to me that all of them had the same question. And the question was, what now? What now will happen to the United States Supreme Court that we have a new president? And Justice Kagan was pretty unflappable. And I wrote down what she said because I knew I'd want to remember it. She said, precedent is a great brake on rapid change. Those who are afraid of rapid change don't need to be so afraid. Those who are eager for rapid change are going to be disappointed. I believe that when justices decide that they know better than precedent and they make change, that we substitute the rule of law with the rule of man, the man or the woman who is sitting in that seat. And I hope that every justice serving on the North Carolina Supreme Court would agree that precedent is very important and that we never substitute raw political power for the rule of law. Thank you.
Thank you. Judge Dietz.
Yes, I'm highly doctrinal, so I care deeply about stare decisis. I agree, in North Carolina, we have some case law that provides a roadmap for when our Supreme Court should be overturning past precedent. And I think it's important to follow that, but as all of the folks who are in this room right now, who are obviously very smart, enterprising law students that got into Duke University's law school, you know that if you try hard enough, you can often find, as an enterprising lawyer or law student, a way to distinguish one case from another, to find an explanation to do something. So I don't think having the case law is enough. You have to have the commitment to say, I am doctrinal and I will follow the law. Now, of course, there are times when you should overturn precedent. I certainly can't imagine anyone making the argument in Brown versus Board of Education that we should just stick with Plessy versus Ferguson because it's precedent. So there will absolutely be situations where a case is just so egregiously wrong, and I think that's probably the greatest example in American history of a shameful decision that our Supreme Court overturned. And we need to trust that judges will have the judgment to know when there's an egregiously wrong case like that and overturn it. So it's important to recognize that, but I think the key is to be doctrinal and to know, to be honest with yourself about, is this one of those very rare cases where we need to take that step?
Wonderful, thank you. So this is a related question. When deciding cases in a way that will shift the law, some jurists believe in taking a minimalist approach. In contrast, others think that there's no need to change the law incrementally. How would you describe your own view on that? And Mr. Allen, we'll start with you.
I think that, as a general rule, courts should decide the issue that's squarely presented, and that's it. I don't favor using judicial opinions to reach out and analyze issues that aren't directly in front of the court. And if elected to the North Carolina Supreme Court, that would be the approach that I would take.
Thank you. Judge Inman.
Yes, as Mr. Allen suggested, courts, unlike a legislature, unlike any other body of government, don't unilaterally make the rules. They decide the cases that are brought to them. And I, too, believe a minimalist approach is best for a couple of reasons. One is, when you make incremental changes in the law and you don't make a sweeping change at one time, no matter how carefully justices have written opinions and thought about those opinions, there are consequences that are unanticipated from every judicial opinion. And if you move the law along very incrementally, you have a chance to see that develop in the lower courts. The second reason is that, and when I clerked for Chief Justice Exum, I saw this a lot, you have 7 justices. If you're trying to reach consensus, finding common ground is usually going to be in a narrower ruling. It's usually going to be in a narrower ruling. And that gives the public confidence that the justices are collaborating and working together, and that you don't feel like you're going to wake up on Wednesday and find out the law is drastically different than it was on Tuesday. Thank you.
Thank you. Judge Dietz.
As I mentioned earlier, 2 key parts of my judicial philosophy are adhering to doctrine and respecting judicial restraint. And I think you combine those 2 together. I agree with my colleagues up here that that means we as judges should be careful only to decide the questions that are presented before us, to understand that we need to be cautious because the integrity of the judicial system is always on the line when we're making decisions.
Thank you. Justice Ervin.
And I would essentially agree with what my colleagues up here have said, but I think there's a couple of things that we need to point out when looking at this at a more granular level. The first is that if you decide an issue that the parties have not fully debated among themselves, the chances that you're going to miss something are exponentially greater. And so, as a matter of self-preservation, if nothing else, it's best to stick only with the issues that were raised by the parties. On the other hand, and this may just come from my own experience as a practitioner arguing cases in front of both the Court of Appeals and the Supreme Court, I do think it's important for appellate courts to address all of the issues raised by the party who is not going to prevail in the case that you're deciding. I can think of a number of occasions in which I, while representing clients, had the experience of getting an appellate opinion that in a five-issue case. The court would talk about the first issue and then just say, and we've looked at the remaining issues raised by the appellant and conclude that they have no merit, period. You should try to convince a client that an opinion that reads that way fairly considered what that party raised. And so one of the things that I've always tried to do in writing my own opinions, or more accurately editing the drafts that my clerks give me, is look at the issues that are raised by the party that is not going to prevail and make sure that you've at least alluded to them or addressed them in some way so that that client will have an idea that, yes, in fact, this court did hear what I had to say, even though the court didn't agree with me.
Wonderful, thank you. We're going to switch gears a little bit and think about past lived experiences. So the question for you now is, can you tell us about someone you view as a role model in the law, someone you try to be like, and why? Judge Inman, we'll start with you.
Well, there's so many people I could think of, but the first person who comes to my mind is Justice Robin Hudson, who's about to retire from the North Carolina Supreme Court. Justice Hudson grew up in North Carolina, and I believe that she went to law school at Yale, or was undergrad at Yale, sorry, but came back to North Carolina. And she practiced law for several years. She had young children, and she was a single mom for many of the years of her children's lives and had to juggle taking care of them, traveling around the state, she represented a lot of workers who got sick in working in the textile industry. She then was elected to the North Carolina Court of Appeals. She wasn't appointed, she was elected. She served on the North Carolina Court of Appeals with distinction, and she did what we've been talking about in terms of engaging with the public, always trying to make sure that regular folk understood how the law worked. She then ran for an open seat on the North Carolina Supreme Court and was elected and was reelected in a nonpartisan race in 2014, and that's when I got to know her very, very well. In the last several years, she's been very active with the National Association of Women Judges and working on materials to explain to regular people, not just lawyers, the nonpartisan criteria by which we can best select judges. And she has emphasized that throughout her work. She is a careful writer and now a grandmother and someone I greatly admire.
Thank you. Judge Dietz.
So you all are going to figure that out, those of you that go to clerk, but the judge you clerk for always becomes a role model. And so I'm now having that how do you choose between your children problem, because I clerk for 2 federal judges, and but I'm going to pick the federal district judge I clerked for. His name was Sam Wilson in the Western District of Virginia, and the reason is because this is going to sound real scandalous, but Judge Wilson is also my father-in-law now. And so this lovely woman sitting in the front row over here, this is, I make a lot of decisions as a Court of Appeals judge. My best decision is my wife, who, this is the first time she could come to one of these forums, so she's here tonight. I did meet my wife, my lovely wife over here, while we were clerking. She had just graduated from Wake Forest undergrad and was home, and so Judge Wilson introduced us. But we didn't get married until years later when we kind of reconnected in DC, so it's not quite as scandalous as it sounds. But what Judge Wilson taught me was just the value of humility, because he was just an absolutely brilliant, brilliant federal judge. I learned so much from him. But when I watched him interact with other people in the courthouse that he would see in the community, and it's a pretty big deal to be a federal judge. As a Court of Appeals judge here in North Carolina, I don't have any kind of security that follows me around. So one thing that's always so funny is how the U.S. Marshals are always there everywhere he's going when he's speaking at events like this. But despite all that, he just wanted to come and talk to regular people and say to people, oh, you found out I'm a judge? Don't worry, I'm of absolutely no moment here. Tell me about you and tell me about your experience with the courts and the justice system. And I've really tried to internalize that and be that kind of judge myself, who can be humble and understand that we're here to serve. We're public servants, and what we just want to do is justice.
Thank you. Justice Ervin.
And I may be in a position of picking between children, and therefore I'm not going to. But the two judicial officials that have had the most influence on my life are my grandfather and my father. As I think I said earlier, my grandfather was a state trial judge and a member of the state Supreme Court. My dad was a state trial judge and was the chief judge of the Fourth Circuit before he died. The things that I learned from them, really, some of them were legal, some of them were personal. The legal was the law applies equally to everybody. Nobody is above the law. And in times like this, where we have some folks who seem to think that they are, we need to come back to that bedrock principle, and my grandfather in particular emphasized that. My father really was a less, to use Judge Dietz's word, less doctrinal kind of a judge. He said two things that always stuck with me. One, treat everybody respectfully. He described one occasion in which he sentenced somebody when he was a state trial judge to a very long term of imprisonment. And at the end of the sentencing hearing, the lawyers did as you always do and say, "Thank you, Your Honor," and then so did the defendant. And Dad said he went up to the bailiff after the hearing was over and said, "Why did he say that? I just gave him a monstrously long prison sentence." And the response from the bailiff was, "But you did it in such a nice way." You learn something from that. And the other thing that he said was, remember that every case you do as a judge has to do with real life situations involving real people. Not that you're supposed to feel sorry for people, not that you're supposed to make emotional decisions, but because of the impact on people of your decisions, you need to take what you're doing really, really seriously. And I try to remember all of those things every day.
Thank you. Mr. Allen.
It's a really tough one. I've known a lot of judges. I know a lot of judges. I'm going to pick someone I didn't know. I have a lot of admiration for Justice Robert Jackson of the U.S. Supreme Court. He was the last U.S. Supreme Court justice not to have graduated from law school. In fact, he didn't go to college. He had 1 year of his academic, his higher academic schooling consisted of 1 year at Albany Law School. He started his legal career handling trials over livestock in upstate New York. But he went on to become Solicitor General of the United States, Attorney General of the United States, and of course a member of the United States Supreme Court. He's the only person ever to have done that. He was the most successful Solicitor General we've ever had. I think he won something like 38 out of 44 cases, and Justice Louis Brandeis said that Robert Jackson should have been made Solicitor General for life. So he had that, astonishing record of professional achievement, but also as a justice, he achieved greatness by authoring some of the most influential opinions that we have on issues like freedom of conscience and separation of powers. And then, of course, he was the chief prosecutor of the Nazi war criminals at Nuremberg. So he did more than any other American to establish the principle that, yes, leaders can be held responsible for wars of aggression. And then finally, he's regarded as one of the 2 or 3 best writers in the history of the U.S. Supreme Court. I know that I'll never achieve what he achieved. I'll never write as well as he did, but it's a great aspiration, nonetheless. Great role model.
Wonderful. Thank you. Well, we're going to sneak one more question in before closing, which is, could you describe an injustice that you have witnessed either in or outside of the courtroom and what your response was to that particular event? Judge Dietz, we'll start with you.
Well, I've been thinking about this actually because expecting to come here and talk more about the state constitution, which we get so many state constitution questions at these forums. I saw something, so this isn't something I've witnessed in the courtroom. I do think this is an injustice that I hope we'll correct as a state of North Carolina. And that is, as I was going through our state constitution, I was reminded there's a lot of provisions in there, they're meaningless because the federal courts have said they don't mean anything. But they're still in our Constitution, and I think we, the people, should get together and remove them. So, for example, there's still a literacy test in our state Constitution. I think we should remove it. I think when people look at the state Constitution, we want to be proud to see those rights that are in there. I think we have a wonderful Constitution with so many special rights that people in other states don't have. And to go down that list and then encounter that sort of thing, I think it diminishes the wonder of our state Constitution. So it's tough to amend the U.S. Constitution, but we've had a fair number of amendments to the North Carolina Constitution. I'd like to see we, the people, get together and delete some of that stuff.
Thank you. Justice Ervin.
Let me tell you a story from private practice. One of the things I used to do was represent people in indigent appeals. And I was appointed to represent an individual whose name I'm not going to give. He's no longer alive. He was charged with conspiring with his girlfriend, allegedly, to murder the girlfriend's husband. The girlfriend was white. My client was black. My client was charged with first-degree murder along with the wife or the girlfriend. The girlfriend was tried first and was convicted of first-degree murder and was sentenced to life imprisonment. My client was charged also with first-degree murder and was sentenced to death. In the sentencing hearing in which my client was involved, the jury, he admittedly actually did the killing, but the jury found that he killed the victim while under the domination of the wife. He got death and she got life. Now, a later governor set aside the death sentence, but when I raised that issue on appeal, I did not get anywhere with it. And that troubled me for many years and still troubles me, how we got there. And so that to me was an example of where the court system initially reached a troubling result, but that at the end of the day, the system wound up doing what it was supposed to, which was to treat everybody similarly situated equally. But at the time that was going on, that was not anything that let's just say I enjoyed participating in.
Thank you. Mr. Allen.
Well, I'll talk about a couple of cases from private practice. They weren't death penalty cases, they were civil cases, but they both sort of illustrate the role that lawyers can have in helping people who find themselves ensnared in our judicial system. In one case, my client was a wrestling coach who had been sued over some abuse perpetrated by some of his wrestlers on one of their teammates. And he was sued by the family of the student who had been abused. And the allegation was that he knew about the abuse and allowed it to go on and even encouraged it. There was actually a significant amount of media attention on that case and on him personally. It turned out that the allegations were pretty much baseless, and I was able to win the case on summary judgment. And what I remember is when I called to tell the man this, he was driving, and he had to pull over. He was so overcome with emotion because his life had been turned upside down. His career had been, put in jeopardy by, some accusations that weren't founded in fact. And I don't know if I have time to talk about the other case, but that case, it was very satisfying to be able to call him and tell this man who was wrongly accused that the case against him was over.
Thank you. Judge Inman.
You know, what comes to my mind is not a huge miscarriage of justice, but a pedestrian moment of injustice that I think happens a lot in a lot of courtrooms and just a lot of places in our society. When I served as a Superior Court judge, I was presiding in a trial. It was a civil trial, and it was a commercial dispute between a gas distributing company and the owner of a small convenience store, gas store. And the owner of the convenience store was born in India and had immigrated to the United States. And he was being sued for not paying the money for these gas pipes that had been installed. And during jury selection, I, as a trial judge, would ask initially questions of jurors just to get through, you know, what part of the county do you live in? Is there any other, you know, and pretty generic questions. And there's one guy on the jury, and I get to the last question, which I always ask, is there any reason that, you know, any reason that you don't think you can sit here and listen to the evidence and fairly and impartially decide this case? And this juror, who had already told us that he makes custom outdoor play equipment and that he's really an artisan, said, well, yes, I'm not sure that I have a question. I'm not sure if I can be fair and impartial because I've had several clients who are Indian, and every single one of them has tried to renegotiate the deal and not pay me for the work that I've done. Every single one of them. I excused that person immediately and took a break, brought the jury back in after the break, and asked each one of them if they could disregard what this man had said. Thank you.
Thank you for that. So we are now at the very last question, which is an invitation for you all to share with our audience. So attorneys, of course, have a wide range of career paths available to them. I suspect that's why many of us are here in this room tonight. In closing, can you share why you have decided to seek this office at this stage in your career, or to seek it again, as the case may be? Justice Ervin, we'll start with you.
Well, I may have the most obvious answer to that question of anybody, which is that it has been a great privilege for me to serve the citizens of the state of North Carolina for the past 23 years at the Utilities Commission, at the Court of Appeals, and on the Supreme Court. Very, very few lawyers get the opportunity to serve on the North Carolina Supreme Court, and I'm deeply, deeply honored every day to have been one of the few that got that chance. And I have enjoyed my work on the court, and I would like to be able to continue to do it. And so I think all of us have to admit that we have personal reasons for wanting to serve on this court. And mine is that I have enjoyed doing it in the past and would like to continue to do it in the future. I also believe that I bring skills to the court that the court can benefit from. The court handles utility commission cases. I'm a former utility commissioner. I have a broad range of jury trial experience and appellate experience. That breadth of experience helps. I understand lots of what goes on in law practice. All three of the lawyer groups who've endorsed candidates in my race have endorsed my reelection. And lastly, I believe that my record shows that I can fairly and impartially decide the cases that come before the court, that I don't make decisions on the basis of political considerations, and in fact have made decisions, as I've said several times, that go against what one would have expected based upon my political affiliation. And so I think that I can continue to serve the citizens of the court successfully. I would very much like the opportunity to do so. And again, thank you all for letting us come and be with you this evening. I hope that I've said something that was of interest. If not, please forgive me.
Mr. Allen.
Thank you all so much for being here and for giving us this opportunity to speak to you. In Federalist 78, Alexander Hamilton pointed out that the executive branch has the power of the sword. The legislative branch has the power of the purse. You know, at the end of the day, the authority of the judiciary rests on nothing more than the trust of the public. The public's belief that our courts are going to act like courts, that they're going to make decisions based on law and not on politics. I'm in this race because I care very deeply about the North Carolina Supreme Court and because I've seen the reputation of the court suffer over the last few years as the court has repeatedly decided politically charged cases on partisan lines. I want to do what I can to help restore the public's faith in our court as a court of law and not a court of politics. I believe that I have shown in my professional life that I take an unbiased and thorough approach to the law. A lot of my scholarship at the School of Government is available online. I invite you to look at it. You'll see that I've written on a wide range of subjects. One thing that I was very proud of is when I did begin this run, so many people I had taught at the School of Government came to me and said, "We had no idea you were a Republican." They couldn't tell from anything I had taught or anything that I had written what my personal political views were. And that's the approach that I'll take to the North Carolina Supreme Court if I'm elected. I'll decide, I'll go to every case with an open mind. I'll decide it based on the facts and on the law. You'll get my honest opinion of what the law is in every case. I will leave my politics at the door. Thank you.
Thank you. Judge Inman.
Thank you. Well, I am in the last few months of my 8-year term on the North Carolina Court of Appeals, and I had a choice to make, and that is whether to run for re-election to my seat on the Court of Appeals or to run for the open seat on the North Carolina Supreme Court. I chose to run for the open seat on the North Carolina Supreme Court for a few reasons. Some of those are the very same reasons that I ran for another open seat on the North Carolina Supreme Court in 2020. I was not successful in that race, but I ran to protect the Supreme Court from partisan politics that are a threat to the independence of our judiciary. Since that election, we have a new Chief Justice. That's the leadership at the North Carolina Supreme Court. We have 2 other new justices. And I'm going to just say a phrase. You could look it up as an SAT question later. It's called asymmetrical polarization. What that means is that in the year 2021, beginning in January and until sometime in December of 2021, the 3 newly elected justices on the North Carolina Supreme Court voted in unison in every single case they heard. So when you hear about these split decisions, it's not evenly distributed. During that same period, the other 4 justices voted together in 48% of the time. I am running for the Supreme Court because I want to make sure that we have a majority of justices who decide cases fairly and impartially and who leave politics out of it and who by all means are not bullied or coerced into towing a political line. Thank you.
Thank you. And finally, Judge Dietz.
So in 8 years on the Court of Appeals, I've traveled all around the state. I've got to experience not just what we do in our state appellate courts, but the courts all over our state in all 100 counties. And I am so proud of our justice system. And I'm so proud of all the people that work in our court system. And I truly believe that North Carolina is a model of how the rule of law can keep us safe and can help everybody grow and prosper together. And throughout its history, the North Carolina Supreme Court has been a key part of that success, and I want to keep it that way. And that's why I decided to run for this open seat on the Supreme Court. One thing I'm very proud of is how, as there's been all this media attention on these Supreme Court races, there's 2 things that have popped up over and over again in the reporting about the candidates, and that is they've called me independent, and they've said when it comes to politics, we don't know with Judge Dietz. And that's because my passion is the law. It's not politics, and because I'm known in the legal profession and in the court system as an independent thinker with ideas about how we can make the courts work for the public. And that's what I'm going to bring to our state's highest court. I think the way to stop the divisiveness that we have in our Supreme Court right now is to have leaders that bring people together, say, let's be a team, And let's respect each other. Listen to those differing views and reach consensus. A lot of people say, how is that going to work? And I'll say, look, I've been on the Court of Appeals 8 years. I've never written a dissent. It's because I work so hard with my colleagues to reach that consensus, and I'm going to bring that to our state's highest court. Thank you.
Wonderful. Well, I hope you all will join me in thanking our candidates tonight for a terrific discussion. Thank you all.